Thank you all for joining. I'd like to start with a few disclaimers, and we are also waiting for one of our guests, Nicolai, to join the webinar. So, first thing is that this webinar is for information purposes only, and whatever views are shared here, they don't amount to legal advice. Second is when we share our track records, etc., past success is not a guarantee of future performance. And also the things we discussed today, including laws, regulations, and timelines, they are as of today, and obviously they're subject to change in the future. With that, I'll get started with the introductions. I'm Abhinav Lohia. I'm the Chief Business Officer at Golden Gate Global. I used to be an EB-5 attorney. I've been involved with EB-5 for a little over 12 years. And prior to that, I used to be an attorney in India, in New Delhi, India, for 5 years. And with me today, I have Rohit from Saul, Ewing and Nicolai from Miller Mayer. I'll let them introduce themselves and their law firms. Gents, both of you are on mute in case you didn't realize.
All right. I'll go jump in. My name is Nicolai Hinrichsen. I'm the managing partner of Miller Mayer's EB-5 practice. Miller Mayer's been involved in the EB-5 industry since it started way back in the 1990s. I've been involved in EB-5 now for almost 20 years. Before turning to EB-5, I was actually a securities attorney until I saw the light and became an immigration attorney. To date, we've filed well over 8,000 I-526 petitions, resulting in the issuance of probably over 15,000 green cards for individual investors and their clients, making us, by volume, one of the largest EB-5 law firms in the world. We represent clients from all over the world, including many hundreds of clients from India.
Great. Thank you, Nicolai.
And my name is Rohit Kapuria. I'm a partner at Saul Ewing. I'm actually one of the co-chairs of the Global Investment Foreign Immigration Program at the firm. We are about 495 attorneys last I checked, 19 different offices. But specific to EB-5, we've done about $12 billion worth of EB-5 offerings till date. We represent a substantial number of regional centers and a substantial number of investors as well. Unlike Nicolai, I've taken the different route. I have not yet seen the light. I am both a corporate securities attorney as well as a project immigration attorney. So maybe one day I'll see the light. So my purview and the way I work on these is because I structure the offerings for a living, we also happen to represent so many investors. We're able to look at things from that level of perspective. And with respect to Indian investors, we have represented a substantial share as well over the years. And so very happy to be here and glad to be part of this webinar.
Thank you, Rohit. And a real quick track record of Golden Gate Global. So we've been in business for 13 years and 1,600 investors have trusted us with their EB-5 investment. We've raised over $800 million. But the number we are really proud of is that we've repaid $250 million to over 500 investors. And we will get into this. So EB-5 investment is not just purely an investment that you invest and you never get it back. There is a timeline for repayment, and we'll get into it when we talk about the requirements of EB-5. Today, obviously, we'll discuss a lot of hot topics in EB-5, starting with what is an EB-5 visa program, a brief historical background, then obviously the bombshell dropped by President Trump about the gold card. We'll address queries related to that. And then we'll get into the requirements of the EB-5 visa program, growing popularity of the EB-5 visa program amongst investors based in the United States on a student visa or H-1B, followed by source of funds issues. And we'll also get into source of funds issues related to Indian regulations as well. So with that, let's kick it off. How about, Rohit, we dive into brief historical background of the EB-5 visa program and then the EB-5 Reforms and Integrity Act.
Sure. So EB-5 has been around since 1990. It's not a new program by any means. It's gone through certain changes, of course, over time, but it's a well-established program that's been bipartisan for a large number of years. Now, the initial inception till probably 2007, 2008, EB-5 was not that well utilized because there was not that much public knowledge about it. But then when we had a credit crunch in the United States, we started to see a huge rise in demand from real estate developers who were not able to borrow at regular market rates. Between 2008 and so all the way to 2017, the main market dominated country of origin for EB-5 was mainland China. However, because of retrogression, which a lot of investors are familiar with, especially if they're born in mainland China or in India, that particular timeline became more and more extended for them from a perspective of visa issuance. Sometime around 2000 and I would say 12, 13, we started to see a bit more of a demand for India, and then it started to increase. And over time, we were able to then get a very mature market to a certain degree for Indian-born investors. But then towards the tail end of 2019, because there was no extension of the program and there were these short bursts, it became somewhat chaotic, if you will, because there was no certainty as to, well, if I'm going to invest right now, what's going to happen? Will I be grandfathered? Will I be able to get my green card eventually? And so there was a brief period as the funds were kind of flowing, but then you had these increase in events where between 2021 at the tail end, middle of 2021, all the way to March 15, 2022, we had no real program. So there was a short bust there. But the EB-5 community was working very hard behind the scenes because of how great this program was. And eventually we got launched into this bipartisan act, which is the EB-5 Reform Integrity Act of 2022. So I want to make that part clear. What we have right now is the law. It's passed by Congress. It cannot be changed without an act of Congress, and it is what currently governs the EB-5 program. So anyone that is investing today, within this particular program is going to be subject to the terms and conditions of the EB-5 Reform Integrity Act, which we shall call the RIA or RERA, however we want to call it in this webinar. And those are the terms that we will be discussing in more minute detail. Now, with the passage of the RIA, where a lot of changes that came about. Number one, there was a focus on where the project is located. So if you're in a rural project or you're in a high employment project, there's different number of visa issuances. There was a provision of grandfathering. So if you are to invest under the RIA, your petition will be grandfathered under the same terms and conditions as to when you do, irrespective of what change may come about in the future. There was a increase in the investment amount. It used to be 500,000, went to 900,000 at one point, but now it is 800,000. And there is what we've seen to be this ability to concurrently file, which is most attractive for investors who are within the United States on a non-immigrant visa and are eligible to file both for the green card as well as for the EB-5 petition. Outside of those four important things, the biggest benefit to all of this was the integrity that's been installed in this. So one thing that we're going to talk about on this webinar, but which has been mentioned in the media of late, is that EB-5 has corruption, EB-5 has a lot of bad things. They're not actually doing what it's supposed to do, which is hopefully incorrect. The one data point I will leave you with before I turn it back is between March of 2022, or rather, I would say September of 2022, when investors were able to invest, and June of 2024, EB-5 raised $6.1 billion. And those funds went into various communities, both rural parts of the United States as well as urban areas. So that speaks to the volume, that speaks to the demand. And that, of course, does not even include all of the hundreds of millions that have come about since then. But yeah, that's a brief introduction to the program.
Thanks, Rohit. That's really helpful. Nicolai, would you like to add anything to that?
I mean, I think that's pretty comprehensive. I think the real benefit, one of the true deep benefits of the RIA is, in fact, the integrity that Rohit mentioned. And I think that's particularly important to emphasize in the current environment and with respect to the announcement by the Trump administration and the suggestion that there is fraud in the EB-5 program and that it's not a quote unquote good program. It in fact is, and the very purpose of the RIA, I mean, one needs only to look at what the name of the legislation is: reform and integrity. This was the focus of Congress in passing that law. It is true that there had been some questionable behavior previously in the EB-5 industry, which, you know, quite honestly, in any moneyed industry in the United States or elsewhere, you have at times bad actors. Bernie Madoff did bad things in the stock market, but it doesn't mean that you don't invest in public stocks anymore. And EB-5 was no different, but the RA really was passed largely to address some of those issues, and it's done a really good job of doing that. EB-5 has matured, whether we call it EB-5 2.0 or 3.0, it certainly is a much more mature program than it was when I started filing EB-5 petitions back in 2007. And just to counter one other thing that was said in the Trump announcement was job creation. You know, EB-5 is predicated on job creation. It's a job creation program meant to benefit the United States. In fact, we'll talk about this later, but you can't get your permanent green card if you can't prove that jobs have been created for U.S. workers. So in that sense, it is a win-win for the United States, and it's unfortunate that there's been some mischaracterization of the benefits and history of the EB-5 program.
Yeah, I agree with you there. There's no doubt that the program was flawed pre-2022, and then Congress got its act together. Not to mention that the program is not only regulated by USCIS or Department of Homeland Security, but also comes under the purview of Securities and Exchange Commission, something you gentlemen are well aware of, because EB-5 units are financial securities. We are regulated by SEC, FINRA. We have to comply by securities laws of the United States, apart from just the immigration laws. So if things do go wrong, federal agencies do go after the bad actors, which is, again, one of the things that was introduced in the Reform and Integrity Act, that bad actors, people with either criminal history or securities fraud history, can no longer be part of this program. So there is a lot of oversight. There's a lot of improvement that took place with the Reform and Integrity Act. Now, coming to the hot topic, we know President Trump blurs the lines between executive, legislature, judiciary. So he dropped a bombshell with his gold card announcement. So Nicolai, would you share what that announcement was and what's the impact of that?
Yeah, so I think the scope of the impact was greater than the content of the announcement itself, which was, you know, pretty slim on details. What was announced was the creation of a gold card, presumably differentiated from a green card, that would cost $5 million for an individual to invest in. And seemingly that investment would not be repayable because President Trump talked about using the proceeds to pay down the national debt. Although he also talked about job creation, and as EB-5 attorneys, it would be kind of difficult to square how those things might work together. But that was the announcement. He didn't specifically say that the EB-5 program should be eliminated, though there was some comment from the Commerce Secretary that that might happen. So subsequent statements suggest that maybe there's a possibility that EB-5 would coexist alongside this new gold card. But again, we are waiting for more details to emerge from the administration. I would say one positive takeaway is the focus on investment migration as a possible solution to issues perhaps like the debt or other issues that face this country. Infrastructure funding, housing funding, things like that are ones that EB-5 can address. And in fact, if you look at one of the key provisions of the RA, we'll talk about this more later, there was a real focus on moving EB-5 investment to rural areas in the United States. And we'll talk about how there's a 20% set aside for rural and priority processing for rural. Those were not accidental provisions. Congress wanted EB-5 money to reach into areas that EB-5 money had not really been deployed in before. And they've been very successful in doing that. So I think when the administration pauses a little and looks at what EB-5 is actually doing today, post RIA, as Rohit mentioned, $6 billion. That's not an insignificant sum of money. So that's the announcement. The impact has been some confusion, but as Rohit mentioned, the law is here, right? The law exists, and only Congress has the power to change or amend that law. That can't be done by way of executive order. So just like Trump came out against birthright citizenship, that is just an announcement. It's just a press conference. It's just a policy position. It has no impact in law. So too, this announcement about EB-5 currently has no impact in law. The program exists. People who are filing today will get receipt notices, and we believe, based on the provisions in the RIA, that people will be grandfathered in until September 2026.
So what you're suggesting is that the president cannot change the laws by tweeting or posting on Truth Social?
That is the thing, exactly. Now, that doesn't mean he can't move policy or opinion. And I think it behooves the industry to explain to people, why EB-5 was characterized incorrectly, and that in fact it has facets to it and features that are a little more complicated and can't necessarily be captured in a soundbite.
Understood. Great. Rohit, can the president change the investment amount just by passing an executive order? Can he scrap the program by signing an executive order?
No, I mean, so, focusing in on what Nicolai said is only Congress can pass a law. Only Congress can initiate such a program in a sense. The president and the executive branch are there to enforce the terms of the law. That's why we have a three-tiered system within the government here. And so, does the president need Congress in order to issue this? Yes. I mean, from a perspective of, you've got visa issuances that come under the State Department. You have USCIS, which actually adjudicates the underlying petitions and determines whether somebody can remain in the United States. And then you have the executive branch, which oversees those two elements, but they can't go beyond that frame to actually do more than that. What I think we're going to end up with, and anything can change, but this idea of having two coexisting programs is completely possible. There are lots of other countries that have investment by migration programs, and they all have this, not all of them, but some of them have this tier where you have one which is at one investment level with its own terms and conditions, and then you have another which is at a different level. And in order to have an offering for $5 million, which is going to be beyond the reach of many people, which 800,000 is already beyond the reach for most people, but you will have to sweeten that in some way. So there's going to be a way to differentiate, but to replace the program that has already been passed, enacted by law, and which has a grandfathering provision. And there was a reason why the industry went after that grandfathering, is because they were focused in on, well, what happens if there's a change in the executive branch? What happens if there's a change in sentiment towards immigration? It cannot just by virtue of executive action, which, to be clear, we don't even have executive action right now. We have statements that have been made in policy. So I think where the industry is falling back on is like, look, there's panic among the investors. There's panic existing and prospective. There's confusion about what the executive branch intends to do. And so there's this movement now to say, we are an industry, we're strong, we're creating jobs, we're providing benefits to investors, but collectively we stand ready to work with the administration to ensure that it meets its own objectives, jobs are created, and to the extent there can be funds that are coming in to pay down the national debt, so be it. 6.1 billion that is already been shown to come in plus the hundreds of millions, which probably we're now close to 7.1, 7.5 billion. All of that were funds that would not have come into the United States but for the EB-5 program. So yes, national debt being at 36 trillion, I don't think any program by itself is going to pay off the national debt, but certainly whatever scraps or dents that can be made, both programs could be lived side by side.
Makes sense. Makes a lot of sense. Nicolai, do you have anything to add to that?
Well, I agree with that characterization. It will not be feasible, of course, to have two programs if the requirements and the benefits are the same. So Rohit is absolutely right. They have to sweeten the pot for the $5 million gold card. One comment that Trump made was that those individuals don't have to pay taxes. That is a big disincentive for very high net worth individuals for moving to the United States because generally they're subject to taxation on their worldwide income. I'm not a tax advisor, I'm not giving tax advice, but that's a general concept that people are familiar with. But if there was some way to insulate a high net worth individual, if they were to get the gold card, that would certainly make it more attractive. One of the benefits to EB-5 that many people point out is, in fact, that tax obligation, right? So you're getting the $800,000 investment that's working in the US economy, but you're also getting all of the sort of downstream benefits, right? An individual and a family moves here, they buy cars, they buy houses, they pay taxes. So the overall economic impact in the United States is certainly not limited to the 6.1 billion that wrote, and it's probably more, 7 billion just in EB-5 financing that has been injected into the U.S. economy. It goes way, way beyond that. But yeah, I think that is a distinct possibility that we do end up with, sort of two side-by-side programs, and that is not at all unprecedented. Also, as Rohit mentioned, many countries have two-tiered systems like that.
And I will just add one last thing to that. If we were to insulate the $5 million gold card investors, there would have to be an amendment to the tax code as well. So it's not what is being discussed. The feasibility of what is being discussed is, it's a high bar to meet, number one. But number two, even if we could get something through an act of Congress in order to pass it, keep in mind, EB-5, it took years to get a program, the EB-5 Reform Integrity Program. And it's not an easy thing. Immigration is already a challenging subject to begin with. But by the time you start to focus in on what exactly is being done, what are the preference systems, how it could be to a disadvantage or advantage of some over the others, that then takes a full focus by Congress to sit back and look at what the bedrock of the Constitution is. So in of itself, again, the industry stands ready to work with the executive branch on this and with the president. But what I'm trying to convey to the audience here is there's a lot more work to be done, and it's going to take time and effort on both sides to make something work. But for the benefit of investors investing today, they have the protections that are in there within the act, and that's what we're relying on and focusing on.
Correct. And if we look at the history of the program starting November 2019, we all know what happened when unilaterally USCIS decided to increase the investment amount to 900K, and then that was overruled. And also, just with that sticker shock, there were hardly any investors that invested in 2019 and 2020. Granted, there was the pandemic, etc., but we had conversations with investors, and they were like, 500K was attractive, 900K, we'll think about it. So if you're talking about a $5 million investment, I mean, and also a documented $5 million investment, that's a lot of money.
It's a whole different level of investor, right? I think that one of the big misconceptions that people have when they don't know about EB-5 and they hear about it is, this is just a visa for rich people to buy citizenship. And that is so categorically false. I am not saying that somebody who's able to invest $800,000 isn't well off, comparatively speaking. But many clients, they're mortgaging houses, they're leveraging assets. up to a very large percentage of their total net worth, right? So there are many people in those countries who own property that may have appreciated to a level of $1 million if they live in major metropolitan areas. Now they're wealthy, but they're not high net worth individuals, right? I mean, you certainly could call them rich in one context, but um, still, they're raising a family and making ends meet, and these individuals are by and large the majority of EB-5 investors that we see. We typically don't see very high net worth individuals investing in EB-5.
Yeah, I agree with that statement. I think a lot of our investors, majority of their net worth is invested into an EB-5 petition, right? And it's for them, it's a generational investment. They're doing it for themselves, but also for their children and, their future generations. So they have a long-term outlook on this green card and this investment, so they feel comfortable with it. There are obviously ultra HNIs doing this for their children, etc. But historically, if you look at ultra HNIs, they get attracted to jurisdictions like Dubai and Singapore because there are tax benefits. They don't want a US green card and have their global income taxed by the United States. So you're absolutely right. Majority of the investors, a major chunk of their net worth is invested into making this qualifying investment for EB-5 and getting a green card. With that, we'll continue with taking a deep dive into the Reform and Integrity Act, the protections, and after that, we will get into source of funds issues, because I know a lot of our investors, prospective investors, they want to know how they can document the source of funds, what's expected. But for now, let's focus on the visa set-asides. Rohit, you touched upon it earlier. There are rural, high unemployment, other set-aside categories. So could you take a dive into that and tell us about them?
So there's a total of 10,000 visas available in the EB-5 program today. And with that, there are 4 categories, so to speak. You have one category, which is rural, that has 2,000 visas. Another category, which is high unemployment TEA, or which is an area typically in a metropolitan area, but tends to have, by virtue of the specific location, an unemployment rate that is higher than the national average. That has 1,000 visas. You have infrastructure projects, which would mean that the underlying development must have government involvement or government utilization and or creation of the jobs, which only has 200 visas. And then you have the balance of 6,800, which is for anyone investing in the program at a non-targeted employment area, which means they're putting in $1,050,000, or they had invested in the program prior to March 15, 2022, and have not yet been issued a visa. So that is how the entire 10,000 visa gets allocated. Now, primarily what we notice in terms of demand is most investors are either going in rural or they're going in the high unemployment TEA. And each one has its own benefits, each one has its own metrics. But first, there's the numerical component. One has twice as many visas in it. But the second component is this concept of what's called priority processing. It's not expedited processing, but it's priority processing, which means that if you are investing at your I-526E stage, then theoretically speaking, assuming the project's received I-956F, which is the project pre-approval by the government, then your petition is going to get adjudicated faster than the other individual who has filed in a high unemployment TEA. But what is important is that faster processing is just on the I-526E. It is not on the underlying I-485 or the DS-260, which is a visa grant at the consulate. So you get in the door, you get faster adjudication of your initial application, but then you fall back into the same regular line with everybody else as to how fast the green card itself is going to get adjudicated. So that's sort of preference number 1. Preference number 2 as to why some people like it is the numerical part, which is particularly important if you are from a high demand country. And when we say high demand country, we're talking about either mainland China or India as of today. And on that basis, you're looking at it and saying, well, what is my prospect of getting into what's called retrogression? Those of you who are here on H-1B and who are born in one of those two high demand countries, who have actually seen what's going on with EB-1, EB-2, EB-3, and what the potential backlog is to get their green cards eventually, would be familiar with this topic. And that's why we notice some of that tug of war, because some people like, they may like a project in an urban area because they're more familiar with it, but they look at the ones in the rural and say, which are just as good in many ways and meet many metrics. And then they say, well, I kind of like that because I understand that environment and that asset class and that location. I really like that one. That's very attractive in the rural area, but I don't quite understand because it's out there and I don't know if it's going to actually be able to repay my loan. What I think we're seeing, and Abhi is going to be able to talk about this from the Golden Gate Global perspective, is the issuers that are making these that are actually funding these projects and putting together their EB-5 offerings. They're not just picking a project because it's in a rural area. They have to do a deep dive. They have to look at the analysis and say, yes, we believe that if we fund it with our investors, this project should result in repayment at X period of time, and we're going to ensure safety of capital. So that's where the discussion starts to happen with investors, is more visa issuances, worried about retrogression, is this very attractive? And then also doing that financial analysis from where the market vantage point is. But I'll kind of turn it over to Nicolai, because he does a lot of that tug of war as well on behalf of investors, to talk about how that kind of works out with his investors.
Yeah, it is the threshold question for a new investor. What category should I invest in? And I think, Rohit, you touched on a lot of the facets of it that an investor has to understand and think about. I think that one can look to the RIA and see that rural was given a distinct advantage, as you mentioned, 2,000 visas instead of 1,000 for high unemployment, and then given the priority processing. So those are two pretty big advantages, right? And the reason that Congress did that is, you alluded to this, is because people tend to think that an investment in a rural area is more risky. And I don't think that's necessarily true. And I will let Abhi speak to this, because as an immigration attorney, I can't advise on specific investment risk, but I can certainly say that from an immigration perspective, I would say a rural investment is better. And why is that? Because I'm hired to get a client a green card. And I'm hired usually to get a client a green card as quickly as possible. And I can most effectively do that if a client is investing in a rural project because of priority processing. Rohit mentioned that priority processing doesn't extend to adjustment of status or consular processing. Those are the two ways that you can get a green card after filing the EB-5 petition, right? So you file the EB-5 petition on a form called an I-526E, and then once that's approved, USCIS can either adjudicate the 485 to adjust status, and we'll talk a little more about that, or you can go and consular process at a US consulate or embassy abroad. But of course, the earlier approval starts that process earlier, certainly for consular processing, for example. So it's true that in and of itself, the process doesn't move faster, but it starts sooner. So for all of those reasons, the majority of clients now really from high use countries like India and China are looking at rural. It is the better option from an immigration perspective, simply because currently our analysis is you're going to get your green card sooner.
Thanks, Nicolai. A couple of things for those who are not aware of various terms associated with the EB-5 visa process. So it's a multi-stage process. The first step is filing for a conditional green card, which is on form I-526E. And if you're here in the United States, you can concurrently file for adjustment of status, which means that you're on a non-immigrant visa. And from there, you have expressed that you wish to move to an immigrant visa, which is form I-485. And once you get the conditional green card, 2 years later, you need to remove your conditions. So you file an application for removal of conditions, or Form I-829. If you want more information on this, we have a ton of videos on 3gfund.com. We won't get into too many details here, but I just wanted to clarify for everyone's benefit, like the Form I-526E is the first step, which is conditional green card. Form I-829 is removal of conditions, and that's the last step to get an unconditional green card. Now, I understand that rural areas have faster processing and twice the amount of quota, right? However, at Golden Gate Global, we have both projects, high unemployment and rural. So what we are seeing, at least with our projects, we are getting 5 rural applicants for every 1 high unemployment applicant. So for us, at least with investors that we are getting, we are seeing 5x more demand for rural, which I'm not trying to make any predictions here, but the double quota for rural may not be as attractive for a lot of investors who are filing today and later, because backlog is based on approvals of petitions filed, and most of them that are filed prior to your petition, right? So do you have any thoughts with respect to numbers, what you are seeing at your law firms? Are there more rural filers, or are there more high unemployment filers?
Who are you asking?
Both. You can, Nicolai, you can go first.
Certainly we see more rural filings now than we do high unemployment. I think, though, that there's a distinction in the analysis of when rural makes sense and when high unemployment makes sense, and that is if you're already in the United States in valid non-immigrant status and you can file concurrently. That is a different situation than if you're outside the United States with respect to choosing high unemployment and rural. And why is that? That is because if you file concurrently, and right now for Indian nationals and Chinese nationals, they're able to do that. If you file concurrently and then say a month or 2 months or 6 months later, there's retrogression, while you will not get your conditional green card for a longer period of time, under the current rules, you will continue to be able to get work and travel authorization in the United States until your priority date becomes current. And I won't explain priority date. People will have to look that up. But generally speaking, if you think about concurrent filing is hugely powerful. You really are basically getting the right to live and work in the United States until you get your green card. And right now, the USCIS is issuing those authorizations for 5 years. So an individual who's in the United States is going to have a slightly different calculus on that. Somebody who's outside the United States, though, cannot derive any benefit from EB-5 until the I-526E petition is approved. Right. And then they can go and interview at a consulate. So all of these issues, if you're listening to this and you're finding this confusing and difficult, it is a little confusing and difficult, but that is more so the case also because to really apply these rules and understand them, it's important for you to seek counsel because your specific facts and circumstances really are going to drive the analysis of the attorney in terms of what they might recommend. How old are your children? How many children do you have? What are your work goals? Do you want to leave your home country right away, or would you rather wait? There's a myriad of different factors that come into play. So really important to not just listen to this overview, but really consult with experts on this before you make a decision to understand what your options are.
Correct. So Rohit, what is the trend you are seeing at your law firm? Are there more rural filers versus high unemployment, or it's the same, or there are more high unemployment petitions?
So I think country of origin seems to also make a big difference, and country of origin by virtue of birth. So we need to make this part clear because I many times will speak to people of Indian descent who, well, they've got a Canadian passport or they have a British passport, and they're focused in on that. So it's where you're born. That's what actually focuses. The other thing that you should also look at and have consultation is, where is your spouse born? Because there's this component of chargeability that you can look at and then make it that decision of what actually matters. But if you are Indian born, or if you're born in mainland China, and perhaps at some point looking at the other higher demand countries such as Korea or Vietnam, Taiwan, depending on how we look at that in terms of categorization, Hong Kong, then that's what's really going to matter in terms of your decision making and then what this potential retrogression is. But as Nicolai is saying, if you're here in the United States and you have that benefit to concurrently file, you're here on H-1B, L-1 status, or some other non-immigrant eligible status, and you concurrently file and you have that benefit, as he also said, of work and travel authorization. In some cases, you may not worry as much because you've got that safety net with your work and travel authorization. And if, God forbid, you get laid off, which has been one of the key reasons we've seen actually higher demand from H-1Bers, is you're not worried about that 60-day rule. Well, I got to find somewhere else. I have to port over my H-1B. You've got that safety of the work authorization and the travel. You may be subject to a potential backlog. And so as far as the differences that we're noticing, what I've noticed in terms of my filings over time is, originally the demand for the Indian born was very much in the high unemployment TEA. And then up until, I would say, 2024, then that trend, we started to see a split off between rural and high unemployment. As of today, we're still filing a substantial number of high unemployment TEA for Indian born, but that distinction is they are primarily here in the United States because they say, well, I'm looking at the calculus. I like this high unemployment TEA project better than perhaps this rural one. But I have this thing of, I'll get my work authorization, I'll get my travel authorization. Yes, my green card may be delayed, but then that flip of what's that calculus? How long are we predicting retrogression is? We know it's coming, but can we actually accurately predict that? No, we're not the State Department. We're not going to be able to tell you that on this webinar. And there are lots of resources out there. Lots of folks have different predictions, but that data is not abundantly 100% clear to us. I think what the investor should be doing instead is not just focused on, I want rural or I want high employment TEA, and then make that decision that way. It should be a work with counsel, a work with the group to say, which one do I like better in terms of project? Because the financial components there. This is an investment. So always remember that. So which one do I believe from a financial standpoint is better for me? Which one do I believe is going to be faster, as Nicolai was saying, will get me my green card? Which one do I believe is going to actually give me the benefit that I'm seeking today? It's an incredible amount of work, but a reminder to everyone on here, an attorney is not going to be able to make that choice for you. An attorney can only give you legal advice, but we cannot give you investment advice. That's where we turn it over to a BN team on the broker-dealer side and who can actually speak to those metrics. And so it's a joint partnership from that standpoint, if you will.
Thanks, Rohit. Yeah, so just to shed some more light on what Rohit said, right? It's about choosing the project primarily, if at least you have that luxury if you're in the States. And I can give an example of two projects that we have at Golden Gate Global, right? We have the Anasu project, which is rural, I-956F approved, has a couple of I-526E approvals. That's a ground-up construction, and it's in the California wine country. At the same time, we have another project in Sonoma Valley, again, California wine country, that does not qualify as rural, but qualifies as high unemployment. And this project is nearing completion. It'll be complete by the end of the year, has created all the jobs. So now it's up to the investors and their comfort level. Do they want to invest in a project which is pending an I-956F approval, but has achieved significant construction milestones, or a project that's achieved immigration milestones like 956F and I-526E, but is a ground-up construction, and it is at an horizontal state. So it is, again, comfort level. And that's what we also tell our investors that, hey, it's your choice. These are the two investment opportunities. And some people like the immigration certainty, and some people like certainty of construction, which also translates into financial security. So it just varies from investors to investors. Um, Nicolai, when you receive queries from new EB-5 investors or prospective EB-5 investors, and they're speaking with you about choosing a regional center or a regional center project, what is the advice? How does that conversation go?
Yeah, so echoing some of the comments that Rohit and I have made so far, EB-5 is a two-track process. It's an investment process and it's an immigration process. And I always have to have this conversation with a prospective client, and I'm calling that individual a client, not an investor, for a reason, right? Because that individual is not my investor. In order to give investment advice, I have to be a registered broker-dealer, and I am not. So, as you have also said, EB-5 is an investment. It's a private placement. It's not like buying Apple stock, but it is a security, and it's subject to certain oversight by the Securities and Exchange Commission, and that's very heavily regulated. So I can't say, well, that Sonoma project is great. You should definitely invest in that. You're going to get your money back. I can't say that, and even though I just did. But what I can do is talk about immigration, and of course, immigration and investment are intertwined in some simple and perhaps complicated ways in EB-5. So generally what I talk about is first reputation, right? So a regional center operating in this space who's structuring a deal must understand what the EB-5 rules and regulations and adjudicatory trends at the time are in order to get that I-956F approved. And just to clarify, an I-956F is a form that's filed by the regional center seeking project approval. That's a separate form from the I-526E that investors file, though the I-526E makes reference to that I-956F for the project details, right? So that's important. Reputation and track record of the regional center operators are very important. And then, contingencies in the project. So is the project going to go forward? Is it financed? Things like that, I think, are also important from an immigration perspective to look at. But at the end of the day, and I said this earlier, EB-5 is a job creation program, right? So victory in EB-5 is creating 10 jobs for U.S. workers. And so ultimately, that is what I would focus on most. We look at the economic report and we determine what the projected job creation number is and when it will occur. That ultimately is going to determine whether or not an individual is able to get their permanent green card approved.
Thank you. And Rohit, how does your conversation go with clients that are exploring regional centers and projects for their investment?
So I think the background of the regional center and the issuer plays certainly a heavy role in terms of those discussions. I always tell them, just because somebody has a very high batting average or gross scoring average, it doesn't mean they're always going to, strike positive. But if they have been doing this for years and they know the market, they know the asset class, then there is some level of ability to say, all right, this may be the right group to go with. And there are a handful of groups out there that have done this over and over and over again and have that track record. So track record, I think, to that extent does matter. The other thing that we talk about is, from just a review of document perspective, because I practice both the security side as well as the EB-5 project immigration and investor immigration, it's hard for me to necessarily leave one hat out of the other. I will need to review the documents just to get my hands around it and also want to be comfortable that that I see where it's going. We do talk about structure of what the funds are going to be, what's the collateral look like. And then the focus really at the end of the day zones back into what's the source of funds, because that's going to be the most critical part. And I know we're going to talk about this, but I will say that by and large, depending on where we see the investor base, some investors are going to look at 15 projects, and we've seen that where they'll pull up a spreadsheet and then they show me their full analysis, and then my head starts to boggle, like, how do you have the time to do this? And how did you get all these metrics? And you must have spent hours. And then some that are just going to look at maybe 2 or 3 projects and then make that decision. We, of course, and echoing Nicolai, we're not going to push you as an investor into one place or the other. We're simply just going to say, these are what our legal perspective is with respect to certain limitations, but we can't project that you're going to get your money back from this guy, or this is the term that it's going to be in terms of what the loan agreement says, or that there's a guarantee that's sitting here. So depending on where the investor is, what is most important to them, we can answer those questions, give them some additional insight, and then see what they prefer. Echoing the 956F approval as well, that's important because 50% of the investment component in terms of the adjudication is done. But while that's very important, the other thing I will say is 956F approved projects also don't have a very long shelf life. And why that matters is you could have a Golden Gate Global that starts off with the project. They filed a 956F. They go into the market because they're allowed to. They start selling. By the time USCIS actually picks up the file and actually adjudicates, because you're subject to their adjudication, they've sold. There's no slots left. And so it's not necessarily a guarantee that you will find a project out there that is 100%, that's 956F approval, which still has slots. So there's that strike while the iron is hot period, and you have to get comfortable making that investment. In like anything, EB-5 is an investment. No guarantee here, but pick the best player with the best circumstances, and hopefully everything works out.
Thank you, Rohit. And just to clarify, right, so you need to be a licensed finance professional to recommend projects. And I'd say almost all immigration attorneys tell you right in the beginning, it's part of their engagement agreement that they will not be recommending any projects. Also, immigration attorneys are not allowed to accept success-based fees for representing investors with a particular regional center. So we cannot compensate immigration attorneys based on their representation of various investors. So most attorneys do it right, and they have their clients' interest at heart when they are introducing regional centers to their clients. And it's usually with historical track record or a historical relationship where the regional center has done the right thing with their clients, and that's why they have confidence in them, and they're clearly not giving you financial advice. We will dive into source of funds, but I want to cover one short topic prior to that, and that is aging out and priority date. And again, I want to clarify, EB-5 is an immigrant visa, so it is based on country of birth, not country of nationality. Your non-immigrant visas are based on your citizenship, whereas your immigrant visas are based on country of birth. So if you're a Canadian national but of Indian origin, you are considered under the Indian quota. With that, Nicolai, would you like to shed some light on how priority dates work? And majority of our investors are on H-1B. We are headquartered in downtown San Francisco, surrounded by all the Fortune 500 companies. So from an EB to EB3 perspective and going to EB-5, would you like to shed some light on how priority dates work?
Yeah, and I'll just add one explanatory note to what you said about country of origin. There is a concept also called cross-chargeability, where if your spouse is born in another country, you as the principal applicant can actually process under that. So if your spouse was born in Canada, you could be subject to the Canadian wait line. There is no line. and skip the Indian line, which is people don't realize that always, and could potentially be important. Aging out is basically an issue that involves the fact that in order to qualify to accompany a filing parent, a child has to be unmarried and under 21 years of age. But the government decided that it didn't want to prejudice or penalize children who aged out. So if you filed shortly before the child turns 21, but then by the time the petition is approved, the child's biological age is over 21, that child would have aged out, is what we say, and they would no longer be eligible to accompany their parent to the United States. A law was passed called the Child Status Protection Act, CSPA, which basically freezes the child's age when you file an immigrant petition. And this law applies in other immigration categories, not just EB-5. So we've talked about the I-526E. Let's say that your child is 20 years old when we file that, and it takes the government 1 year to adjudicate that petition. Well, your child's biological age would be 21 when the I-526 petition is approved, but their visa age, because of the CSPA, is the age they had when it was filed, 20 years old, and therefore they're eligible to immigrate with their parent at that point in time. Now, we have talked a little bit about the process after I-526 approval. So what happens if you're in the United States? You can file an adjustment of status. If you're outside the United States, you have to go and interview at a consulate. The unfortunate thing with CSPA is that it only really covers that period of time while the immigrant petition is pending. So if you're abroad and the child has a visa age of 20, that age starts to tick again once it's approved, and the child has to take certain steps to secure a visa in time before they age out. And of course, if a waiting line has developed, because of that waiting line, they can't take those steps and they can age out. There is a slightly different and more charitable rule that USCIS has recently disseminated, and that is if you are concurrently filing in the United States and you file a 485, that act in and of itself freezes that child's age, and they would not age out. So there's a different process for consular processing and adjustment of status with respect to kids that may age out. This is quite a complicated area of EB-5 law, and I've given you an overview of it. I hope I haven't confused you too much. Again, if you have kids over 16, 17, I think that you should be talking about these kinds of issues with a qualified immigration attorney to understand what the consequences are and what your options are.
Thank you, Nicolai. Rohit, would you like to touch upon priority dates? And I get this question a lot from H-1B visa holders that my EB2 priority date is 2015. So does that mean they'll get a green card in 2025? It's 10 years of retrogression, or the timeline does not work one-to-one?
Yeah, and unfortunately, timeline doesn't work one-to-one. What one needs to not necessarily look at, because the data is not abundantly clear, but what one needs to focus in on is if you've got, a perspective that's saying 10 calendar years, well, what exactly is the total number of demand of individuals that are pending? And a lot of individuals who are here, who have pending EB2, EB3 petitions, or even EB1 at this point, they've been flip-flopping between the different categories just as they're getting additional qualifications, if you will, that or meet the requirements in order for them to file those. And then you have this flip-flop that happens, or you have some that start at EB3, then they file an EB2, then they file an EB1, they're crossover all three, and they're trying to just see which one is going to result in a faster situation. Now, the State Department issues what's called a visa bulletin. A lot of folks are familiar with it, some are not. And that goes on a monthly basis. It tells you what the State Department is determining on a discussion basis that it has with the USCIS based on how much demand they're seeing, as well as what they're seeing at the different posts in terms of requests for interviews through the National Visa Center. And then they make a calculation and say, all right, we feel that we need to adjust the number backwards or forwards on that month, or keep it static based on what we think the demand looks like. Unfortunately, for investors born in mainland China or in India that are in an employment-based capacity where they're an H-1B, they have a pending EB-2 or EB-3, if they have a filing priority date that is easily any earlier than probably 2020, and I'm sure the number is even worse than that, but I'll throw that out. I do not see, unfortunately, how that they will be able to get their green card faster than if they go under EB-5. That's the unfortunate reality. It sounds like it's not that much, 5-year difference, 6-year difference, but we are also trying to compare against what the demand is. The demand under those categories far exceeds what the demand is under EB-5, right? Because for those, we have a wealth of individuals who have those qualifications that meet the criteria, work for very good companies, but that number is far higher than the number that's going for EB-5 and can actually afford the EB-5 program. Now, that could change over time based on where we're seeing demand, but there is a reason why we are seeing the substantial number of Indian-born or Chinese-born that are here on H-1B or some other immigrant status that are filing in EB-5. It's because of the priority date issue and because of the backlog.
Right. So if I'm an H-1B visa holder, or for that matter, student visa, F1 or L1A, O1, E2, right? And I have a 19-year-old or a 20-year-old child. If I file for EB-5, as long as it's current, and concurrently apply for adjustment of status, will my child's age be frozen at 20, and will my child get the green card with both parents? Nicolai, would you like to address that?
Yes, the answer is yes.
Great. And the other question is, when H-1B visa holders apply for their children and they are adjusting status, they have a pending adjustment of status application, do these kids qualify for institution at universities?
So that maybe, state schools and private schools differ in terms of what the rules are to qualify for in-state tuition. So there is an analysis that needs to be made there, but it is certainly possible that they would qualify for in-state tuition. It's also possible that they would qualify for grants or student loans that they wouldn't otherwise qualify for as just an F student. But again, the rules applicable to that are going to differ depending on the program and the school.
So I guess it makes a lot of sense if someone's child is 16 or 17 to file an EB-5 petition when they're about to attend college and they may qualify for in-state. And most importantly, their age will be frozen. So if under EB-2 or EB-3, it's taking them 10, 15, 20 years to get a green card. But with EB-5, because it's current, the child's age is frozen, and they could get, even if EB-5 takes 4, 5, 6 years, again, the entire family is getting a green card together, right?
Yeah, and it's important. I mean, if you have a strategy that involves education, it's important to assess where your child might go to school. Having just put my daughter into her first year of college, I recognize this is not an easy thing to do, and you may look at many schools and where your child ultimately ends up going. It's difficult to predict. But nevertheless, you can look at how long a person, for example, might need to live in that state in order to qualify for in-state tuition. So you can certainly be strategic about it. And the savings are pretty significant. It's not inexpensive to send a child to school in the United States. And so if you can avail yourself of in-state tuition. That certainly is something that'll impact your pocketbook.
Well, congratulations on that.
Thank you.
Let's now hit the source of funds topic, and we'll do it like a case study. So Rohit, I'll first ask you, we've spoken so much about the H-1B visa community, right? So if I'm a client, I'm on H-1B visa, what are the suggested sources of funds, or what are the common sources of funds that H-1B visa holders or L-1 visa holders use while they're here in the United States?
Commonality I see many times is sale of stocks, shares, either RSUs or things that they've accumulated over time based on salary income. Sometimes we see, sale of real estate as well, just because if you bought in the Bay Area in 2000 versus what you're trying to sell now or whatever it is, I mean, the capital it's definitely appreciated. Going back to what Nicolai talked about, appreciation properties in urban areas, metropolitan urban areas. We see combination of funds that have just accumulated over time based on their work, started work at X company, moved to Y company, got bonuses as they were jumping from company to company. So that's many times what we see. Where you see a bit of a twist then at some point is they've aggregated that much here in the United States, and we can source all of that. Of course, there's a level of forensic analysis that goes into this. So one thing I want to make very clear is I get a lot of calls, a lot of initial calls with investors, and it's always, my source of funds is very easy. It's very straightforward, and it's all income earned in the United States. Sure. But by the time we finish, a 20, 25-minute discussion, it ain't that easy, because then we've really opened up a lot of things that they hadn't thought about, and what they've done in terms of their activity. But the additional twist will come in where a portion of my funds is coming from India, and it's a gift from mom and dad, and it's their salary earnings. Great. Now we got to go open up mom and dad's accounts and then figure out what's going on there. So it's the thing about the EB-5 program is the vetting process is very intense. Call it extreme vetting if you want. Harking back to one of the statements that was made in the press conference is, there's corruption and fraud, and if you use the other program, there'll be a lot more vetting. That vetting is currently being done now. If you look at the qualifications of the individuals that are working in the investor program office, which is that distinct EB-5 unit under USCIS that's allocated for EB-5. These individuals are the most sophisticated USCIS officers that there are. They're high-level employees, GS-15 and above. They have graduate degrees. They are, lawyers. They're MBAs, former finance folks. And so if you look at what they are adjudicating on, there's a lot of intense scrutiny that they do because they want to make sure that the funds are clean. And so the typical H-1B-er, you could have that appreciation in stock, appreciation in real estate, but we will still run you through the gamut in how did you aggregate and save the money. And then to the extent you have other funds that are coming in, to the extent somebody is lending you money, and that's a concept we'll talk about today, keep in mind that we are also going to open up the coffers of the lender, just to understand where his or her money is coming from, as opposed to simply saying, sure, it's a loan. The RIA is very specific on this. If it's a loan, and if it's not coming from a bank, then we need to source where that is coming from. So there's just expect that amount of time. And as you're working with counsel, an inordinate amount of time is going to be spent on it. Now, someone coming to me today saying, hey, I need to file EB-5. It's current for the month of March. We must file in the month of March. It's possible. And, I'm sure, I don't know if Nicolai will say the same thing, but certainly it's possible and it can be done. But it would really depend on where your source is coming from and then whether we're comfortable actually filing it based on where your source is coming from.
Thanks, Rohit. You touched upon something really important here. trying to file as soon as possible. We get a lot of rush cases. So Nicolai, I guess, apart from adding to Rohit's thing about various sources of funding, could you also shed light on partial investments?
Yeah, partial investments are a very good strategy and one that's endorsed by the USCIS in the form of approvals and guidance that whereby an individual can invest less than the full investment amount, typically $800,000, and secure a positive priority date, and then invest the remainder at some later point in time, typically by way of what we call an interfiling. We will get a receipt notice for the initially submitted I-526, and then we will interfile with additional evidence. It's a very good strategy in certain situations because, again, you are able to secure a priority date much sooner. For example, I have a client who had about half the money in RSUs and the other half was coming from a house sale in India. Well, that takes time. We know the money is coming. So we chose the strategy of filing with using the stock sales first with a little description in the source of funds that the money would follow and that the source of it would be a house sale. So that is definitely a strategy. I would caution in all of this, and Rohit mentioned this and used the term forensic accounting. This is highly technical. This is highly complicated stuff. There are not a lot of immigration attorneys in the United States that can do this kind of work well. And so whether you decide to work with Rohit or me or someone else, I strongly encourage you to make sure that the immigration attorney you're utilizing specializes in EB-5. This is not something that a general practitioner immigration attorney should be taking on. That could be malpractice. It is highly technical, and it is something that is subject to some change. Rohit and our firms do pretty high volume of work with USCIS, so we get constant feedback about what adjudication trends are, and they might be looking at something a little more closely. And for example, partial investments. So I think that's very important for people who are listening to this and who, that maybe you have a great relationship with your existing immigration counsel. They got you into the US, you've had them over for dinner, they did your L or they did your H. They're probably not the right person to do your EB-5. And if they're honest about it, they'll tell you that.
If I had a nickel. Rohit, let's touch upon the loans, both secured like a HELOC and unsecured.
Okay. It's a complicated history. And as Nicolai was saying, a lot of the patterns that we look at is on the basis of RFEs and what feedback we get from USCIS. So you have the policy manual, which is USCIS's publication on how it's actually going to adjudicate petitions. So you have the RIA, which is the law. And then you have what the agency does on a fairly consistent basis, which is the adjudications can turn into inconsistent adjudications. So that level of consistency is not necessarily always there because they could have an issue that they start to see more frequently and decide, okay, we're going to start paying attention to this. And then we will then, as we're noticing that in our volume trends, we'll start to adjust our analysis and adjust to what we believe their team to be focusing more their efforts on. So at the end, of course, the integrity of your funds is paramount. Now, HELOC or unsecured, secured loans, the question that pops up is, what is the basis of that? And they've been litigation over time. There are several different cases that have come about in the last 8-9 years that carry some level of precedent value, which is USCIS focused in on one point, and then they kept hammering that over several cases. Someone then sued, and they went to district court, went through an appellate, and then finally USCIS lost on the issue, and then they had to walk back some of those trends, and then that's what we now use in our adjudications, or rather in our analysis. But HELOCs and loans are permissible. It's been done time and time again. The question that arises on the unsecured, which I'll take first, is it needs to make sense. So on the face of it, does it make sense that somebody is going to lend you X amount of money? Number one. Number two, if they're going to lend you X amount of money, the law says who that person is, we need to source their money. Again, if it's not a bank, why is it that this individual is willing to lend you $300,000, $400,000 and not take any security, any collateral? Number one. And number two, where does their money come from, right? So it may be a family member, it may be a best friend, but we will need to get into their books and records to understand their source. Now, the rationale, USCIS doesn't say this, but what the thinking is they want to make sure that this lender is not simply taking money that was passed by the investor in the background over to this investor and then lending you back the same proceeds, right? That's something we have to get around. And we have to disprove that assertion. The second on the HELOC is if you are taking a loan against your home, well, then securitized. And so USCIS has a right to actually understand what is the background of that asset. And so we will then look at when did you buy the property? How much did you buy it for? What was the source of your down payment? So those of you here in the United States that have gone through the mortgage perspective and your lender has done that analysis on your down payment, think of that and then multiply it by 10. That's the source of funds process. We are going to have that magnifying glass similarly to understand how you did that and then how you've supported your EMI payments over the past amount of time. And then we'll look at what the HELOC looks like and what you can take out. So it's an important source of funds. We see that time and time again for H-1Bers, but understand that the analysis is quite intense as well. So I will keep coming back to that statement. It's pretty intense.
Nicolai, do you have any thoughts on this topic?
Intense. I think a very common misconception, the one that I encounter most often is somebody who has tax returns demonstrating an income well in excess of $800,000 and just doesn't quite understand why that's not enough. And, that is, I'm not saying that's not good evidence. It certainly provides a context for the petitioner that is useful for USCIS in assessing whether or not this individual is a criminal or has earned the money in some unlawful way, right? Their educational background is important. Things like that you can highlight to contextualize, tell a story to the adjudicator. That's important. That's what I try to do. I try to tell a story. But at the end of the day, you have to get into the nitty gritty. It is forensic accounting, and that is the standard that USCIS uses. They are supposed to use a standard called preponderance of the evidence, which is the lowest possible standard, evidentiary standard in US law. It has to be 50.0001% more likely than not that what you are saying is true. In fact, USCIS probably uses a much, much higher standard than that, and we're used to that. We will fight back if they ask for something unreasonable. Rohit was mentioning demonstrating how you purchased a house. Look, if you bought a house 2 years ago, the expectation is that you're going to be able to show exactly what money you used to buy that house. I bought my house in 2007. I could not document in any detail how I bought that house. I can go up in my attic. I can look through all sorts of boxes. I can ask my bank. I just couldn't do it. And it's not reasonable to ask me to do it. And in fairness to USCIS, they do understand that. Does that mean that they don't want any information about how I bought the house? No. We have to get creative and think of other ways that we can make the USCIS comfortable. And that's where we really leverage that standard of evidence. And also where, Rohit and I, not to put words in your mouth, Rohit, but this is where our experience comes into play. How do we manage the gaps in the evidence, and how do we position this person and their story in a way that will result in EB-5 approval?
Thanks for that. Well, apart from source of funds, I think path of funds is equally important. So again, Nicolai, to you, would you like to shed some light on on path of funds, and what does that mean?
Yeah, so path of funds means that essentially USCIS wants to be able to follow the money through the banking system or any other transfers, interim transfers we call them, until the money is invested in the regional center project. So let's say you sold a house 5 years ago and you took the proceeds from that house sale and invested it into Vanguard, Fidelity, and Robinhood, and maybe one other. And then you move that money among all of those positions, and maybe you added more money, and so you had gains and you had losses. Well, now we're no longer just looking at a house sale, right? We're looking at investment gains, and we then need to be able to follow that path of funds, which now has gotten intermingled with perhaps other money that an individual has put in after. So that is extremely technical, very forensic, and a critical part of EB-5 because it's kind of the easiest kind of gotcha evidence that USCIS has. It said, well, we don't see this transfer from Bank of America to Robinhood, in 2022. We need that so that we can know that this is the same money. Again, we have strategies that we can employ, but it's very risky to have a gap in that path of funds.
Thanks for that. Rohit, would you like to shed light on path of funds from an international perspective, remittance, etc.?
Yeah, I mean that's where the partial investment also plays a role, right? If you're subject to the remittance caps on certain countries of origin, India, mainland China, Vietnam, all of these countries have those limitations. The path of funds also is the same, where we're trying to ensure to the best reasonable extent possible that the funds that we've sourced. So what we always tell the clients from the very beginning is, if we've sourced this, we've gone through hours and hours and hours with you sourcing this money. Let's be sure that it's quote unquote the same money that it's now going to make its way, right? It was in rupees, and you then put it into your HDFC account, and then from that account, you're now going to get it remitted through these other accounts. Maybe you're going to have, other family members who are sending you on behalf. Let's make sure it's the same corpus. So you can't tie serial number to serial number, but that's the sort of perspective you should be having so that we can do it. And then as you're moving it through that banking system, through the various accounts, and we're showing those the credits and debits, eventually it's going to end up in the escrow account for the underlying project. So that is what we need to present to USCIS. Can you avoid it in certain circumstances? We're not going to complicate this webinar with talking about money exchange services and the like, which is a whole different 2-hour discussion. But you should be consulting with counsel. And what is very important, I tell people, don't liquidate, don't start the investment process, don't move money out of your respective country until you work with counsel. It's very difficult for us as professionals to start playing catch up, because if there was a mistake in the system, if you mixed in your money with other money along the way, that opens a can of worms that we may not be able to close. So, yeah. So while everyone wants to rush, let's rush with you, rush under our guidance to the
Right.
extent we can give you guidance.
We will run with you. No, I can think of an example from my past experience as an attorney. There were a few of my clients back then that used LRS, their $250,000 limit, to transfer funds to the United States without consulting me. And then when we were going through the source of funds of money, it was broken. Now here we are with $250,000 in the United States of funds that we cannot use for EB-5, and they've exhausted their limit for the year. So then you go to your various relatives, etc., figure out how to get another $250K to fund your EB-5 investment, and trust a relative to remit the funds overseas. So it's very important for EB-5 investors to engage an attorney and work with them from scratch. Because an attorney's job is not only to document your source of funds, but also identify the best way of funding your EB-5 investment, what USCIS will understand, and it's about keeping it simple. And I think EB-5 attorneys are known for it. So with that, gentlemen, thank you for your time. Parting notes, starting with Nicolai.
This is, you know, you used the word bombshell at the top of this seminar, and obviously there are a lot of controversial things happening in the Trump administration right now, and this bombshell regarding EB-5 is not the least of them. I think that I'm hopeful. I'm an eternal optimist, maybe. I do think that once the dust settles and cooler heads prevail, the administration will see the benefit of EB-5, which, after all, is a program that the Trump family itself has used in the past. And Donald Trump is a deal maker and is a real estate developer, and because of that, I think it stands to reason that he and his administration, if explained properly, could see the benefit of EB-5, and I'm hopeful that this is what will happen. And again, that perhaps the best outcome of all of this is that there is a coexistence between the legacy EB-5 program and the new $5 million gold card.
Thank you. And Rohit?
On that same basis of optimism, I mean, look, it right now you could take a look at it from two perspectives. Either get dissuaded, sit on the sidelines until you have some level of clarity, whenever that may come. We don't know what the timing is. Or you could push ahead and proceed. We have clients on both. We cannot advise a client take the plunge today or wait. I am certainly, or we are collectively all certainly dealing with a lot of folks that are asking that question almost on an hourly basis. Should I, could I, what, did I do this wrong, blah, blah, blah. The only thing I can say to all of that is we have an act. It's law. It's here till September 30th, 2027. There's a grandfathering provision that's part of it. If you are from a certain country of nationality, it remains your best option in terms of the quickest path to residency. And we're going to continue following that because that's the rule and that's the law and that's what we have guidance on. Until we get something else that supersedes it legally, that's the path that folks should follow. Now, beyond that, the benefits of the program for development, for job creation, and for the investors, the data is there. Proof of concept is there. It's incredibly sustainable and incredibly beneficial. And to the extent we can help you, Nicolai, myself, Abhi, we would be pleased to assist down the line.
Thank you, Rohit. Well, thank you both, because the original intended time for this webinar was only 1 hour and we are well above that. So thanks again. And I mean, always a pleasure speaking with you. For our attendees, thank you for joining. I'm sharing a link in the chat with a video library of like basics of EB-5. Please go through it. And if you feel like you need to schedule an appointment with Rohit or Nicolai, let us know. We can facilitate that, or you can reach out to them. And thank you all for joining.